Good evening, everyone. Today, we are covering a very critical topic that will resonate with all the HR partners and employees. On this very short note, I would like to welcome Satyendra Shrivastava, who is a partner at Khaitan Legal Associates. Satyen is a corporate lawyer and heads the HR and employment practice at Khaitan Legal Associates. He regularly advises international and domestic clients on a range of labor and employment matters. Satyendra also leads the insurance practice at the firm. He is an alumnus of the London School of Economics. He was a journalist with a leading business daily in Ahmedabad before taking up the legal profession. He divides his time between Ahmedabad, Mumbai and London. Along with Satyen, please join me to welcome Ms. Lakshmi Rai. Lakshmi is an HR and legal professional. She comes with over 15 years of experience working as HR and legal person in most of the jobs. Currently, Lakshmi is heading HR and legal functions for Firework in India and C Firework, which is a venture-backed startup based in Silicon Valley in Redwood City, California, with offices in Los Angeles, Tokyo, Moscow, Mumbai, and Warsaw. Lakshmi has completed her MBA in HR from Pune University. She is a law graduate with specializations in IPR and IT. She also holds a degree in psychology and master's in English from Nagpur University. Let's me not take more time and let's get on with this topic for today. Satyen, over to you.
Thank you, Aruna. I'm thankful to J B Boda for this opportunity. Without further ado, I will start with the presentation. Let me see. Okay, so we are in very interesting times. These are unprecedented times, we all know. Before our call, before this session started, we were having a chat amongst ourselves, Lakshmi, Aruna, Chaitanya and I, there was some very interesting discussion on how HR professionals are dealing with this situation. And the new paradigm within which the HR industry would operate. So these are interesting times. I always joke with my friends that I've never felt as important. In the last 2 months, I've felt more important than ever as an employment lawyer. Most of the times, your regular M&A, corporate, and other lawyers tend to steal the thunder, but in the last 2 months, it's the employment lawyers that everybody's been talking about. So in today's session, what we intend to cover is the rights of the employees, the obligations of the employers from the point of view of the lockdown and beyond lockdown. What are the challenges for the employers in implementing work from home, etc., and the employers' rights post-lockdown. We will also have enough time for questions, but I leave it up to Lakshmi to decide as to how she wants to play with the questions. We are there, so Lakshmi, please feel free to interrupt, and we'll try to make it as interactive as possible.
Absolutely, so, yeah, let's start.
What is it that we are dealing with here? We all know that this is a history-altering event. 2 months ago, nobody knew that we would be heading into a situation like this, which is going to change everything for us. Neither did we know, nor did the government know. So in that context, if you see the various steps and the measures that the government has taken, it needs to be understood and appreciated in that context. And I will take a moment here to introduce you to how the labor and employment regime works in India. In India, it is the central government which legislates most parts of employment laws, but the implementation is done by the state governments. It is also important to note that within the constitutional framework, labor and employment, they are a part of the concurrent list, which means both the center and the state have the right and the ability to legislate in that front. Now, apart from social security laws like Provident Fund, ESIC, gratuity, etc., all the other laws, even where the legislation is being done by the central government, the implementation is done at the level of the state governments. So it's a very interesting interplay of central and state laws. Similarly, as far as working conditions and other rights like leave, holiday, etc. is concerned, that is purely a state subject. So, in that context, one has to understand as to how the government reacted when the early news of, when it was clear that, we are heading into a pandemic and the government will need to take some actions. So what did the government do? The government invoked the Disaster Management Act and the Colonial Era Epidemic Diseases Act 1897. I have to make an admission here that before coronavirus struck, I was not even aware that there was a law like Epidemic Diseases Act, which was there in the statute, because I had never seen something like this. Similarly, the Disaster Management Act, although the government, this was enacted after tsunami of 2004, the fact that the national lockdown could be imposed under the act was something which was, there on the statute book, but nobody had experienced it. And let me, explain this to you so that you understand the gravity of the situation. That even when India went to 3 wars, right? We had full-fledged wars in 47, 48, 65, 62, and 71. So 4 wars. There was never a situation where a nationwide lockdown had been imposed. So this situation is very unprecedented in that sense, and therefore, the obligations that have been imposed on the employers must be understood in that light. So what did the government do? The government realized that the regular legislative measures or the regular legislative avenues that the government had, if it wanted to impose something, was not available. So what did the government do? That the governments used Disaster Management Act and the Epidemic Diseases Act to issue certain orders, and those orders started coming from the Ministry of Home Affairs, which is the nodal agency for the implementation of the Disaster Management Act. Now, once those orders started coming in, the government started also improvising or altering those orders as we went along. So, for example, in the initial bit, the government issued advisories. So the Central Labour Ministry issued advisories to state governments, and the state governments issued those advisories to the respective constituents on what they need to do with the rights of the employees in wake of the pandemic. However, courtesy lawyers like us, most private sector felt that these advisories were only recommendatory in nature. They did not have the force of law. So there was, a polarizing view. So the industry was divided as to whether they need to implement the early advisories or not. When the government realized that the situation is getting out of control, they issued an order under the Disaster Management Act on March 29, which mandated that the employers need to pay full and complete wages to all their workers. Okay, so this implied that nobody could terminate any employee, including casual and contract labor, and they needed to pay them in full. Now, this circular, this MHA order of 29th March, that created a lot of furor among employers. And mind you, unlike any other situation where an infraction or a breach in an employment law scenario would typically lead to a civil liability. Okay, you will be either required to reinstate the employee, or reinstate the workman, or pay damages and so on. But here, in Disaster Management Act, any breach of the order of MHA would result in a criminal liability. So which means that as an employer, if you're not implementing the directive under the Disaster Management Act, your senior management could potentially face a criminal action in the form of an FIR. And believe me, more than 25,000 FIRs have been filed in different parts of the country with respect to breaches under Disaster Management Act. I'm not saying that all the FIRs relate to the breaches by employers, but the situation with the breach of Disaster Management Act is clear. So the employers were taken aback with this notification, with this order, and the larger view within the legal community was that the 29th March order had the force of law. So we were in a situation where many petitions were filed, and as of this date, the government is supposed to file its reply with respect to one of the petitions that has challenged the order. Although we will come to the position that the order no longer applies, but it is important for you to get the flavor as to what happened in the first 3 phases of lockdown. So moving on. So if we have to divide this, so from March 25 to May 17th, the position as far as the obligations of the employers was very clear. Okay, you could not terminate any employee, you could not reduce the wages, you could not force them to take leave. Okay, post 17th May, that is starting from May 18th, the last set of guidelines that came under the last order of MHA, it was very clear that the previous orders with respect to, including the one which was causing a lot of discomfort to employers, that order no longer was in effect. So to give some relief to the employers, they have, as matters stand today, they have some flexibility and liberty to do whatever they wish to with their employees, subject to other applicable provisions of the law. So let's move on to the actual session. So this background was something which I tend to emphasize and sometimes overemphasize, because it is very important for for the stakeholders to understand as to where was the government coming from, what were the obligations, and what is the risk or the liability that they are facing. So COVID-19 and employment, we all know that this has a deep and a far-reaching impact on the employment sector. The International Labour Organization has tagged the COVID-19 crisis as one of the most important, one of the most significant crises since Second World War. There has been a significant decline in economic activity, and this there has been decline in working hours as well, naturally, because of that. There are certain sectors which are considered as high risk because of the disruption. There are certain curbs and restrictions on employers during lockdown, and that is something that we discussed, that the employers, their hands were tied. There were certain restrictions and prohibitions that they were facing. Similarly, lockdown 1, 2, 3, and lockdown 4. So we need to, as I said, draw a distinction between what was the position until lockdown 3 and what is the position now, with lockdown 4. So coming to where we stand today. Okay, so the MHA order on lockdown 4.0, So we all know that the nationwide lockdown has been extended till 31st May, but the permissions, the restrictions are not the same as they were, until lockdown 3. So what is the main what are the main parts of this? What are the main features of the MHA directives with respect to lockdown 4.0? The first and the most important one is that the contentious MHA order of 29th March, which mandated payments of wages, which is also challenged in the Supreme Court, that stands withdrawn. Okay, so secondly, the MHA order of 15th April 2020, which required mandatory medical insurance for workers, that has also been withdrawn. So you will note that many employers had these questions as to to what extent they need to provide coverage to their employees. Some employees are covered under ESIC, some employees had other coverage. Whether the coverage was restricted till lockdown or whether they need to provide medical coverage for around the year. There were several questions that the employers were struggling with, but the good news for them is that MHA order, which required mandatory medical cover, that stands withdrawn. Similarly, there are detailed standard operating guidelines that have been issued under the MHA order. For example, there needs to be a staggered opening of various activities and sectors. The employees, insofar as workplaces are concerned, all the employers need to comply with certain standard operating procedures, and we will discuss that in further detail. And the other important aspect was that state governments would have the liberty to issue their separate guidelines for the in relation to the containment zones and the other demarcated zones under the order. So there are these red, orange, and green zones. So that the larger framework was decided by the MHA order 4.0, but the other aspects, which is if the state governments want to make it stricter or they want to impose more restrictions than what the latest MHA order says, the state governments have the flexibility and the ability to do so. Now, what are the other aspects that that relate to the obligations of the employers? To ensure the use of Arogya Setu application by all employees, there were certain concerns on privacy and data breaches, etc. But all of them have been resolved, or the government has tried to address them through several press releases and other statements. Initially, the use of Arogya Setu was mandatory for all employees, but now the government has diluted this requirement under the MHA order, and now it is no longer mandatory. The employees, but the employers should, on a good effort basis, ensure that the employees use Arogya Setu. Similarly, employers should ask the employees to carry out operations from home to the extent possible. Now, if you see, this has been a consistent requirement or a consistent stipulation across all the MHA orders with respect to lockdown. Working from home is a concept that is not statutorily recognized in India, unlike many other jurisdictions where there is a detailed statutory and a regulatory framework with respect to working from home. In India, except for a few companies, most of them don't recognize or don't offer this as a part of a regular offering to their employees. things may change now, and maybe Lakshmi, when we are discussing these issues threadbare, she will be able to throw some more light on this. But so now there is a clear-cut direction in the MHA orders with respect to working from home. Similarly, there is a requirement, the obligation is on the employer to ensure that all the national directives issued by MHA and all the guidelines and directives issued by Ministry of Health and Family Welfare are strictly complied. Staggering of work and business hours, this is something which is also clearly set out, that earlier when lockdown, when the third phase of lockdown was announced, in certain zones, which is green zones, the government had allowed establishments to reopen with 33% workforce, and now they have enhanced it, and they've asked the establishments to get back to resume duties on a staggered basis, with 50% workforce. Similarly, there is an obligation on the employers to use thermal scanning, hand wash, sanitizers, etc. at entry and exit points. There needs to be a frequent sanitization of the entire workplace, common facilities, and all the points which come into human contact, like door handles, tables, chairs, etc. Interestingly, the Ministry of Health and Family Welfare have also issued guidelines with respect to the closure of establishments if at all there is any worker or any employee found to be infected with corona. Similarly, social distancing and adequate distance between workers is also something that the employers are they are mandated to follow. So, as I said, and just to re-emphasize this point, that the sad story for employers, and the ambiguity, the anxiety was limited and restricted to lockdown 3.0, which is until May of 17th, because until the 17th of May, there was no flexibility, no recognition of the right of the employer to restructure their operations. Nothing was available. Okay? After after May 18th, there is this, and after the withdrawal of the MHA order of 29th March, now the employers have the ability to go back to the pre-COVID scenario and look at restructuring, downsizing. I don't like to use the word downsize though. I mean right sizing, and restructuring the packages, etc. So here I'll take a minute to just kind of outline the obligations of the employers from a regular employment and labor regime as to what the employers can or cannot do. So the Indian law with respect to industrial relations or employer-employee relations, it draws a distinction between two categories of employees, the workmen and non-workmen. Workmen are typically those set of employees who render non-managerial and non-administrative functions, and there is a wage threshold which needs to be read in conjunction with the principal nature of their duties. So essentially, those employees who don't qualify as managers or who don't render administrative duties, and if they render supervisory duties, they earn less than 10,000 rupees. They would qualify as workmen, and the others would not qualify as workmen. So why this distinction becomes essential? Because the workmen enjoy protection of law. The non-workmen, which is managerial class and the ones who are who don't qualify as workmen, they have very limited protection at law. Their protection starts and ends with their employment contracts. So when it comes to reducing the numbers, which is when if you're looking at retrenching or downsizing the employees, you will need to comply with the mandatory obligations under the Industrial Disputes Act with respect to workmen. With respect to non-workmen, as I said, that they don't have, or rather they have very limited laws. They have very limited protection under laws. So, it is easier and you have a greater flexibility in terms of downsizing that segment of employees. With respect to workmen, they're entitled to statutory retrenchment compensation. In certain cases, if you have 100 or more workmen in certain states, this threshold varies. Even if you want to retrench a single workman, you will need the prior approval of the state government. So this thing varies, but depending upon whether an individual is a workman or a non-workman, you have the flexibility of retrenching them and downsizing. Similarly, with respect to reduction of wages, now as matters stand, the employers have the flexibility and freedom to restructure the wages in accordance with their business requirements. However, one should be mindful that if you are reducing the wages of a workman, then you will need to comply with the requirements under the Industrial Disputes Act. Under the Industrial Disputes Act, there is a requirement of 21-day notice that needs to be given mandatorily to the workmen if you want to reduce their wages. With respect to non-workmen, just to re-emphasize, they don't have this kind of statutory protection. So any kind of a reduction in wages will have to be done in accordance with their employment contracts or your handbooks. One question that is often asked is that whether the employer can defer or suspend increments and bonus for employees. Again, one thing one must be, one thing that should be clarified is that increment is not a statutory right. So, if at all you wish to defer the increments, or if you want to suspend increments as an employer, you have the right to do so. However, in cases where you have made a written commitment to an employee who qualifies as a workman, maybe you will need to follow the process of giving them appropriate notice and then not implementing or withholding any kind of increments. There are, in cases of companies which are subsidiaries or branch offices or foreign offices, we often see that in employment contract, the employers often grant that right that they will mandatorily give increments year on year. So if that is the situation, then you may have to deal with it differently. That you may have to seek a waiver of that from the employees in case you want to implement the deferral or suspension of increment. Similarly, for bonus are of two types. The statutory bonus, which is paid under the Payment of Bonus Act. Now that is something that you will not be able to defer. However, Payment of Bonus Act is paid only to limited set of employees. I mean, statutorily it extends to only a particular segment. As far as contractual bonus is concerned, as per the terms of your employment, you could either withhold it or defer it. You have the right. Again, if it's for the workmen, then you need to follow the requirements under the Industrial Disputes Act. So, moving on, the challenges that the employers would face, when employees start working from home. Now, we've, as I said, that in many countries, in many other jurisdictions, there is a clear-cut framework on the rights and obligations of employees and employers with respect to working from home. In case, in India, we don't have a statutory or regulatory framework yet. But what we have seen, interestingly, that employers have been trying to navigate through the various challenges that this new normal is presenting. Now, the immediate challenges that come to our mind, from a legal perspective, are cyber security and cyber data breaches. The more remote access to your internal systems and networks, the greater is the threat of any kind of a cyber intrusion. So there, you may require interventions, from a technological perspective. You may also need to relook at your cyber insurance as to whether it gives you protection for working from home kind of scenarios, and so on. Similarly, the other challenge that we face is the breach of confidentiality and data protection. We know that in India, especially when you're dealing with IP sensitive matters, or when you're dealing in areas where data is critical, it is very important to ensure that one rogue employee who's sitting in some corner is not able to abuse the work from home such that the interests of the employer are compromised, or the employer is subject to or exposed to certain risks from third parties or under law, which could have a detrimental impact in the longer run. So there again, from an employer's perspective, you will not only need technological interventions, that there is no unauthorized access, or there is no breach of confidentiality and data protection, but you will also need certain contractual safeguards, so that if you get the employees to sign certain additional documents with respect to their obligations on confidentiality and data protection, it will be helpful. Last but not the least, productivity and performance tracking, and this is something which Lakshmi will be in a better position to expand and explain as we go there. But it is always a challenge for the managers and for HR professionals to ensure that employees who are working from home, they are productive, they are involved, they are engaged, and they at least perform their duties with the required level of attention and diligence. So from a technological perspective, maybe there will be certain performance tracking measures that will have to be deployed by HR professionals when dealing with working from home.
This is again,
Yeah.
Satyen, there's a very thin line between, managing and micromanaging. That also HR needs to keep in mind during this work from home culture. Because if you are doing a micromanagement and every day you are on your employee's head that how they are utilizing their 8-9 hours of work, and you are tracking their productivity, that might go wrong. So there's a very thin and fine line that HR needs to understand and then implement that performance and tracking and productivity tracker.
Yeah, it's very interesting. You raised this point because in our discussions with many of our colleagues, and law firms are a different kettle of fish. But nevertheless, what we get to hear is that their productivity has gone down, but the number of hours that they are spending is significantly higher, and that is causing a lot of stress. That is causing a lot of grief. So I think you're right that even we may take some time in terms of adjusting to this new world that is unfolding in front of us.
Yeah, the new term has come, that lockdown burnout.
Lockdown burnout, right? Yeah.
Yeah.
So,
and somebody has posted a question here that's related to your previous slide, Satyen, that what about performance bonus? That Pradnya has posted this question.
Yeah.
So this
yeah.
is Pradnya. Though Satin will explain better in his view, what I feel about performance bonuses. Definitely, you deserve to get your performance bonus for the period that you have worked. If it was for last year's performance and you are supposed to get this year, but due to this unique situation, your employer might not be in a position to disburse that performance bonus immediately. He might disburse in parts, or maybe he will give you some maybe disbursement slots that he'll disburse that amount in 3 quarters, next 3 quarters, or next 1 year. But again, having said that, there's your performance bonus is also linked with company's performance. So if company is going through this downfall during this pandemic, that your performance bonus will definitely get affected, because the company's performance is getting affected.
So, so Pragnya, let me disappoint you further. Performance bonus is not a statutory right; it's a contractual right. So, as per the terms of the agreement, the employer would have agreed to pay you that performance bonus. Now, when you are, if you are not a workman, okay, and given that it's not a statutory payment, okay, the employer has the ability to restructure that at any point in time. Okay, so even if it means that the employer is breaching the agreement, okay, the remedy that will lie that you have is to seek compensation for breach of contract. And given that you would want to continue your employment, the employees would not want to take that route and challenge the employer. So to answer your question, there is very limited recourse that one has if the employer wishes to either freeze or defer or suspend the performance bonus. Right? Okay. So, okay. Now, the essence of whatever we have been discussing, right? What can you do as an employer? So the first and the foremost is that, okay, comply with all the directions and advisories from the central and the state government. Okay, that is the easiest thing that any advisor would tell you, that okay, you need to comply with law. Then what else do you need to do? You need to assess your risks in case of non-compliance. Okay, so it was very interesting that during the lockdown, and again, I'm drawing this distinction because in the previous session that we did on employment law, it was a different world. Today, when we are talking about the rights and obligations of the employers, it is a different world because employers are heaving a sigh of relief that controversial March 29 circular no longer exists. But it is very important to assess your risks in case of non-compliance. So given that many employers were facing cash flow problems, many employers during the period of lockdown, even when they were not, when they did not have the legal ability to reduce the salary or to terminate, they still went ahead and did that because of the compulsions that they were facing. So in those situations, you need to assess your risks in case of non-compliance, which means that if the policeman were to come knocking, and if there is an FIR filed, what you need to do. Okay. Similarly, you need to reserve rights while paying employees. Now there may have been occasion from the point that the lockdown started that you may not be wanting to there could have been certain situations where you may have perhaps wanting to take a disciplinary action against an employee, but because of the lockdown, you were not able to take that action, and you were bound to then make payments to such employees. So in all such cases where in your view there was in your view you were not mandated to, you were not required to make the payment, but you were still making it in light of the government order, you need to reserve your rights while making payments. Similarly, in any difficult time, the best solution, and this is we always as lawyers say that there is law, there is practice, and the truth lies somewhere in between. Okay, so as employers, the sure shot thing to not fall in any kind of a regulatory or a statutory trap is to ensure that you keep the engagement with employees alive. Okay, you'll be surprised to know that there are employers who were successful in getting the offers from the employees to reduce their pay during the first, second, and third phase of lockdown, which means that eventually they ended up not substantially complying with that order, but they were not in breach because the employees themselves were asking for a pay cut. Okay, now that all of that happened because the employers were in continuous engagement with the employees. You see, ultimately, what both parties have to understand that they are working towards the for each other's benefit. Now, from an employee's perspective, it is better to take a 20% cut rather than not having a job at all. So, it's very important and very critical to keep the engagement with employees alive. Similarly, ensure safety procedures at workplace. The obligation under the MHA order is on the employer. So the employer must ensure that all the national directives with respect to standard operating procedures issued by the Ministry of Home Affairs and any guidelines that are issued by the Ministry of Health and Family Welfare, including any guidelines issued by the state governments and municipal corporations, which are in whose jurisdiction you operate, you need to comply with all those guidelines because that is mandatory, and the obligation is on the employer. Similarly, follow practices for regular sanitizing and disinfecting of the workplace. This again is as per the Ministry of Health and Family Welfare's guidelines. Okay. Now, one specific request that came from Aruna, while we were trying to curate this session was on leave and holidays. So should we take it right now or should we answer other questions? What do you suggest, Lakshmi?
We have this, we are covering this in our Q&A session, so maybe we can cover that.
Okay, all right. So, should I address this right now?
We can, or I'm just saying that we can finish the session and we can cover that during our Q&A session.
Yeah. So now we then proceed to the questions. So
cool.
We can now answer any questions that they have, so that.
Okay. So let me start with the Q&As that we have received so far. Okay. So Pradna has posted one question. If the employee catches the COVID while on job in office transport to and fro office route, will eligible for compensation? That's Pradna's question.
Yeah. So there is no requirement for there is no under the MHA orders, there is nothing specific with respect to compensation. But we will have to see whether there is an eligibility under the Employee Compensation Act with respect to the employee contracting the infection during the course of the duty. Now, given that the transport, the requirement to provide transport was mandated under one of the MHA orders, the likelihood of such a requirement, a compensation requirement under the Employee Compensation Act, there would be an entitlement under the Employee Compensation Act.
Correct, right. And the second question somebody has posted is, Nimisha has posted one question. if an employee has exhausted leaves and then test COVID positive or is quarantined, do we pay for those days? So your thoughts, Satyen, then I'll add my inputs.
Sure. So you see, the leave provisions with respect to leave, they vary from across the states. So in certain states, the government has specifically declared that any person who is tested positive will be granted 28-day leave. So in Uttar Pradesh and in Telangana, we see that the government has allowed that. In this case, in states where the government have not come up with, the state governments have not come up with anything specific with respect to the leave provisions. My understanding and my view is that they will have to exhaust their regular sick leave or casual leave with respect to the COVID related if they are taking leave on account of the coronavirus or COVID positive, if they're found to be COVID positive.
Correct. In addition to this, Satyen, I would like to add one more point, and I would like to take your inputs on that. Now we are in a different situation, a very unique situation. It's unlike 80s and 90s, wherein we had these bucket of leaves like sick leaves and casual leaves and your personal leaves. So we are working towards diminishing and these categories of leaves, and we are preferring getting merged all these basket of leaves that we used to be. So do you think sick leave as a category should be a mandatory, or what does the law say about it?
So it's an interesting question, because again here, there was across India, the practice used to vary. Okay, it still does. There are certain states which are more liberal with sick leave. Interestingly, in the state of Maharashtra, for establishments, for non-industrial establishments, which is the service sector, there was no statutory concept of sick leave until 2017. Right. So in 2017, when the new Shops and Establishment Act came into force, there was a recognition of sick and casual leave. Okay? Right. So having said that, it is very critical that whenever HR managers as well as employers, when they sit together and try and determine the leave framework for establishments, it is important to ensure that the minimum requirement under applicable law has to be met. So for example, in the state of Maharashtra, where you need to provide 8 plus 18, so 18 earned stroke annual stroke privilege leave, plus 8 casual cum sick leave. Now that you're obliged to provide. So if the law recognizes that you need to provide sick leave, you have no option but to provide it, right? Similarly, if you are in Delhi also, it is like 15 plus 12. Okay, so 15 days of earned leave and 12 days of casual leave, casual right. Cum sick leave. Okay. Right. In state of West Bengal, it's very interesting. In state of West Bengal, in other states, you're not allowed to accumulate your sick and casual leave. In the state of West Bengal, you can accumulate your sick and casual leave up to 64 days. So this varies across state, but the thing to note and the thing to follow is that if the law requires a minimum benefit to be granted, that minimum benefit you will have no option but to grant.
Right. Right.
Sorry, absolutely. Sorry to intervene, Satyen, but I was just itching to ask this question. So each state will have a different rules to follow for the leaves pattern. What if a particular company who is headquartered in Bangalore and has a multiple location, Mumbai, Pune, Gurgaon, in major metros, then what kind of a pattern that they should follow? They should be having a staggered leave system or a one uniform leave system?
So they can't have a uniform leave system. Or rather, if they want to have uniform leave system, then certain states will get more more benefits than the other states. So I'll give you an example. Okay, so for example, if you are if you're in Bangalore, or say and you have an employee in West Bengal, okay, then what you will have to offer, as I said in the earlier, that you need to offer the minimum that the law prescribes. Okay, so this desire to have uniform leave policy across the state, it becomes it is a non-starter when it comes to a place like India, where every state has a different approach to leave and holiday. I mean, for example, holidays, like if Ganesh Chaturthi is a big festival in Bombay, okay, why would you give a holiday for Ganesh Chaturthi to an employee or who's based in Calcutta? Similarly, if in Calcutta there is Durga Puja, why will you give give a leave, give a holiday in in a place like Bombay? So it's very important that and this happens typically with subsidiaries of multinational companies or their branch offices. They would want to reconcile their leave across India, because sometimes you have softwares that work, and sometimes you have IT systems that need to support this. But it is important that you draw a distinction. Or what you could do is that you could have earned leave or privilege leave uniform, which is the highest, and you could create separate systems and frameworks for non-earned leave, like casual and sick leave. You could vary, keep it you could vary it for different offices across India. I don't know if that answers your question, Aruna.
Pretty much, it all depends on HR. So Lakshmi is the bonus in your court.
Yeah, absolutely, Satyen. Yeah, very valid point. And which again, I'll be just adding one more thing to it. Because we'll be, after this lockdown phase is over, we'll be into a new work culture. We'll be adapting to a lot of new things. There'll be a lot of things that I think being in HR or the management team will be introducing, considering the COVID situation in mind. One of the situation would be the leave and the holiday plans that people used to plan for their employee may not be used take their annual leaves like the previous year they had planned, or there will be no vacations this year. I think everybody is cautious. Travel is restricted. A lot of things are restricted. Do you think it's high time employers should work on the leave rules, the leave policies, and or we should maintain the status quo? Or if yes, what are those changes, and what do you suggest on those?
It's something which is many HR professionals are grappling with this as to in the new normal, how will this entire leave holiday concept work? Like if you have 80% of your employees working from home, whether and if they are hot desking, coming like 3 days in a week they come to work, and other 2 days they work from home, or a mix and match. How will be the interplay of leave and holiday? It's an interesting question. But as far as law is concerned, okay, as I said, that you will be required to grant them the minimum that the law requires them to do. Okay, so for example, if under the Shops and Establishment Act, you need to give them a holiday for 15 January, 26th, 15th August, 26th Jan, 2nd October, and 1st of May. That is something that you will have to provide them regardless of whether it's their day to come to office or they're working from home and so on. Okay, and then you will have to also develop a mechanism whereby you will have to ensure that they are on holiday on those. It is actually a holiday for them because the law requires you to do that. Okay, and the same thing goes for your privilege leave and other sick leave and
sick leave. Yeah.
So what the law requires, you ought to give them. Over and above that, there is an American company that we work with. They interestingly gave last Friday as a holiday because they thought that people are facing a burnout, sitting at home working, so they need to be taken care of, and therefore they added one holiday to their one leave to their already existing leave allowance, to say that because you're working from home, it is stressful, you please take something extra.
That's something we need to really keep in mind while working on these things. Okay, so I think I miss taking some of the questions, and I kept asking my queries. Sunny has posted one question. Will employee contracting COVID-19 due to his visit to office manufacturing plant, would this be considered as employer's liability? I think we had covered this thing somewhere.
Yes. So see, anything during the course of employment, would be the employer's responsibility, and we will have to see whether it is covered under the Employees Compensation Act and so on. But yeah, primarily the liability would sit with the employee.
Okay. There's one more question from Pratna. Oh, after lockdown opens, if the employee voluntarily choose to work from home as to secure himself and to take care of his elderly parents for a certain period till the situation normalizes. However, he is active 100% with work from home. Does the employer has the right to cut the salary or leaves? I would be extremely interested in knowing this answer.
So see, so long as the employer is paying the minimum wage to the employee, okay, the employer has the right to restructure the wage as per his own will. Okay, you keep the context aside, whatever be the reason, even if the person is coming to work, you still have the ability to reduce his wage, given your business circumstances, your economic circumstances, and so on. So regardless of the context, the employer has the right, but the employer will need to follow the the protocol. Now, whether they should do it or not from a moral perspective, from an HR perspective, that is a different question. That is perhaps, you can answer that, whether from an HR perspective they should be doing that or not, because it may send misleading signals, or it may paint the employer in a bad light. But from a legal perspective, the employer has the right.
See, again, from HR point of view, it completely depends upon the situation, the financial situation of the company sitting. Though a lot of companies consider themselves as, employees are their brand ambassadors, right? And they would want to take care of them. But then a lot of things depends upon company's financial situation. For example, I'll give you an example of the production houses. A lot of their financial rollout depends upon the number of shows they have on the floor. Right now, everything is locked down. They are not producing any shows. They are not getting, monies are not coming in. So a lot of things will get affected because of this. So this is from the HR point of view, and legal you have already shared. Okay. So we have one more question. If an organization, okay, I missed the other one. Although the MHA has withdrawn the circular for insurance coverage, still while applying for opening up the office warehouse, Part B of the form states that you have to mandatorily cover the contractual staff even though they are covered under ESIC. What are your views, Shekhar?
So can you this
question? Can you read this question here on the chat?
I can read the question, but maybe.
So Satyen, even my question is the same thing, which I was asking you also offline. In the time to come, will this ESIC will become obsolete, or ESI will still continue to be there as a part of an ecosystem? So I think Jacob is also want to understand whether ESIC continues, and can we have another layer over and above ESIC?
So see, ESIC is a different. ESIC is a social security legislation, right? And ESIC coverage is only for certain qualifying employees. There is a wage cap to what the employees. So for the employees to qualify as a beneficiary of ESIC, there is a wage cap. Okay, so ESIC is not applicable to everyone. What the MHA order said was providing insurance cover providing mandatory medical insurance to all employees. Now, given that there was certain set of employees who were already covered under ESIC, at that time the view of lawyers and of practitioners was that given that the employer is already providing a coverage, or rather the employees already have coverage under ESIC, they may be outside this mandatory medical cover that was being offered, that was being mandated by the government. Okay, so but they were mutually exclusive. They were not kind of working, although they intend to provide coverage to the employees, but they work in separate domain. So, the question that he's asking is that he's referring to Part B, and I assume that Part B is refers to some insurance policy.
Yes.
Right. So they have to mandatorily cover the contractual staff, even though they are covered under ESIC. They're two separate things. So now given that circular is already withdrawn, so ESIC operates in a separate domain, and we can't be mixing the two.
There's one question Sanjeev has posted here. I would like to answer this thing, but I just want to take your view, Satyen. If in organization there is no provision of leave encashment in the new normal, if employees cannot take leaves for going to their hometown or for tourism purposes, normally there is a limit up to which leaves can be accumulated. What will happen to the leaves, or will they lapse?
Yeah. So firstly, one clarification: leave encashment is not a right. Okay, leave encashment only happens when you are leaving the employment. So upon termination or cessation of employment for any reason, you have the right to encash your leave. Okay, that is number one. Number two, as far as accumulation of leave is concerned, this again position varies from state to state. Okay, in the state of Maharashtra, that cap is 45 days. So any accumulation beyond what the law stipulates, that lapses. So unless the employer wants to willingly offer you something voluntarily out of their own choice, they are not obliged to offer. So once the number of leaves that are accumulated crosses 45, they lapse.
Correct. Law is silent on this, right, Satyen?
Sorry, with respect to?
With respect to this encashment of earned leave during the employment, law is silent, and employer can decide to allow leave with wage to employee or may encash the value of the leave, if I'm not wrong.
Yeah. So, but what law offers is that law does not grant it as a statutory right. So, if the employer wants to give, well and good. But what employer will also have to take into account that given that leave is also a right of the employee. Okay, employer cannot impose encashment and say that, okay, I'm not going to grant you any leave. You just take the money and come to work every day. So that kind of a situation may not be legally tenable.
But in the current situation, in COVID situation, where people are not utilizing their leaves and it's getting accumulated, and suppose after 3 months, if anybody decides to resign, and will this accumulated leaves will be considered as a payout if the corporate wants to pay out?
Up to 45 days, they can encash. Okay, beyond 45 days, it is difficult. And see, Aruna, 45 days is a lot of time. It's like if you don't take a single earned leave for 3 years, okay, then you reach 45 days, right? And we are just talking about like a couple of months here.
Right. So there is one question that I have received. Few of employers believe additional leaves as burden impacting productivity. One of that is maternity leave. So what is your view on employee benefit on a long-term period, particularly for the maternity benefit? I have a different view completely. Being a mother, I feel you need 6 months time to set a new routine in place, whether pandemic is there or not.
You're right. And we should not confuse between those two. See, pandemic is a temporary situation.
Absolutely.
That we all have landed ourselves into. Now, that's not going to interfere with the regular rights that you would have otherwise under other laws. So Maternity Benefits Act is a beneficial legislation. Okay, it is a beneficial, it is a legislation that also has traits of social security into it. So one cannot mix the two. Your rights that are available to you under Maternity Benefit Acts do not get compromised or enhanced because of the pandemic situation. That is separate, and you will continue to be entitled to get those benefits subject to your eligibility and so on.
So let's be unbiased over here. What about paternity leave?
There is no paternity leave, unfortunately, in India. Under law you don't have. There are many organizations that provide paternity leave. in India, but that is as a matter of policy and not under law.
So Satyen, accumulated leaves lapse on account, or the somebody has posted also the specially earned leaves. Is it legally right?
Yeah. So see, what does the law say? The law says that you cannot accumulate beyond 45 days. Okay.
Right.
So as a matter of right, or other, that right will not be, you cannot claim that as a matter of right. But if the employer wants to give you as a policy, then employer has all the ability to do that. I mean, the employer is not restricted.
Do you think employee can file a complaint against an employer for not providing sufficient or adequate leaves?
Yes. In India, we don't normally, because if you see, the balance of power between an employer and an employee, is heavily tilted in the favor of the employer. Okay, so for issues like leave, extension of leave, etc., employees would, in my 15 years experience, I have not seen any employee filing a complaint for this. They could file complaints for other issues, but as far as leave is concerned, even culturally we are not aware. Indians, we don't take enough leave, we don't switch off, and I would like to blame the HR people for that, not lawyers. But
I'll take that blame.
All right. So theoretically, I mean, there is always a right. You can go and complain, but practically nobody does that.
Yeah, because the need or the possession of an employee could be different from employee to employee basis the circumstances,
They
right?
also need to show evidence, right? That they have asked for a leave and the leave has been denied. Now, if everything is
so, on what stage employer is liable? It can't be first day I went. I'm asking for a leave. You denied. I cannot go to courts, right?
Yeah. Yeah.
So, what stage an employer is liable?
No, so it would depend upon whether on the first day the leave would not have even accrued. So
Right.
if I have been denied, see, the employer also has the right to deny leave. So if you translate the meaning of the word leave means permission, right? So leave also means permission. So when you seek leave, is that you're seeking the permission to go on a holiday, right? Or absenting yourself. So from that point of view, the employer has the employee has the right and the privilege to ask for leave. The employer may, subject to certain circumstances, deny it, and if he is denying it, there needs to be an adequate compensation that need to be paid, okay, to the employee under respective. The position varies across different states, but then the employee also has, so apart from that compensation, that employee would still have the right to take that 18-day leave, at least in the state of Maharashtra. So I ask for leave, I am denied, I am compensated, but beyond that, I still have that right to take that pending leave during that leave period. And then if I don't get that leave, I have the right to accumulate it up to 45 days, which is around 2.5. So if I don't, if I'm not granted any leave for 2.5 years, then I would reach a situation where I would have accumulated 45, around 40, 44, 45 days.
Right. Absolutely. And another thing that comes to my mind is that Karnataka government recently declared 20 days of leave for COVID positive employees.
Yes.
However, other states are silent on the same.
No, so
why there is not a single rule on the disease that spread impacted pan India? Why other states are not taking any?
See, state of Uttar Pradesh has also ordered, in one of the notifications. Yeah.
Recently.
I think 28 days. Similarly, Andhra Pradesh and Telangana also have some provisions. Okay, but because it's a state subject, and the central government can only interfere to a certain extent, right? I mean, as it is, there was a big debate on whether the central government had the ability to issue an MHA order mandating private establishments to pay wages. That itself was being challenged. So if they would have even allowed leave, it would have just created, another set of controversy.
Right,
And
right,
they don't even have, frankly, they don't even have that right. That right rests with the state government in our scheme of things.
right. Absolutely. So I'll take just a couple of more questions, and then we can just circle back to. So my next question is slightly technical that I would want to know. Does Disaster Management Act 2005 and Epidemic Disease Act 1897 gives any direction to state government on leaves framework as a part of employment?
Interesting. Yeah. So the Disaster Management Act doesn't, but the Epidemic Diseases Act says that the state governments have the right to undertake whatever necessary actions they wish to take, in their respective jurisdictions. So if you will see the notifications that have come out in several states with respect to mandatory paid, like for example, Telangana came up with this notification which allowed, which said that all the employees will be paid mandatorily during the, they will be entitled to paid leaves during the first set of lockdowns. So from 25th March, Telangana went into lockdown 2 days before the national lockdown. So from 22nd March to 31st March, all the employees were entitled to mandatorily paid leaves, right? Even if they're working from home, not working from home whatsoever. Now that notification came under the Epidemic Diseases Act,
Right.
paired with the Shops Establishment Act. So the authority to the state government to take certain actions was under Epidemic Diseases Act. It is not specifically with respect to leave, but certain state governments have extended it to grant leave or to play with leave, the leave framework. Right.
Yeah, this explains. Thanks. So the last question to you is something that a lot of my friends who are working in IT sector have been asking me, and I was waiting for this thing to ask you. So in the IT sector, in SEC or DOT, STPI, allow work from home only from base locations. Why such limitations? Why it is not helpful for any, because this is not helping in them in this situation of pandemic. Do you expect any changes in guidelines, and why this situation?
So again, this is I don't have the ready-made answer for this, but my understanding is that special economic zones, STPIs, etc. They come within a special regulatory framework. Okay, so they are demarcated zones, they are gated zones where people go and work, and there are certain advantages and benefits that the establishments enjoy. Okay, including with respect to IT in particular, there is something called the OSP license. Okay, that is given for the use of bandwidth. Now, if the employees work from different from other places, then the likelihood, then there is a gray area in terms of how those benefits will be available to that establishment or to others. And that's why what has happened that with many special economic zones, with many software technology parks, with many financial services centers within special economic zones, the government has not gone ahead and implemented this. Okay, so and therefore, accordingly, the employers are also insisting for the employees to come and work. So that is my understanding. There could be something else as well. Also, from a practical perspective, in many cases, like not big cities, but these special economic zones are in demarcated, separate, secluded areas. So there may be a possibility of managing social distancing, and so on in a better way as compared to other regular establishments which are located within cities. So that could be another reason. But I don't know the rationale behind it, but yeah, it is very clear that government, even in the second round of lockdown, had given certain exemptions to special economic zones, and they had said that regular activities could be permitted there. So there could be a separate risk assessment by the government in respect to SEZs.
Okay.
Does it answer the question?
Yes, absolutely. That helps. Okay, there are a few more questions that we'll have to take offline because we have already extended our timeline. I would request Aruna to take the lead. And thank you so much, Satyendra, for such an insightful session that helps. I think all the attendees must have received and must have got the answers of their queries and whatever questions they had in mind in this situation and this unique situation that we are coming out with. And hopefully all of us will be back to the new normal out of all this difficult situation. So over to you, Aruna.
Thank you so much, Lakshmi. One last question that was playing in my mind, because we support most of our clients on the crash facilities. So now the crashes, now all these crash facilities are stopped. The maternity law said that the corporate should be providing crash facilities or aid the employee with this benefit. Now, when the crash facilities are stopped, and the employee will have to stay back home to take care of their children. So in such cases, what are the obligations of an employer towards the employee?
Yeah, interesting one. So crash facilities are also under the Factories Act. So not only Maternity Benefits Act, but the Factories Act also requires you to provide certain crash facilities if you have, if the total number of employees exceed a particular number, right? Now, you know, it's an interest. There is no straight answer for this, Aruna. You know, if the employee is staying home and working from home because she needs to take care of a child, you know, only because the employer is not able to run the crash facility, that would, in my view, given that the maternity benefit is a beneficial legislation, you know, from the objective of the act, you know, the employee, the female employee, will have a right to claim that, you know, she is not able to discharge a regular responsibility because the employer is not able to discharge their responsibility under the act, and therefore it should be treated like a special case. So the advice would be that the employers should look at this thing in a more liberal manner, full of, you know, they should be considerate, and they should look at the larger objective of the act, and therefore you know, deal with the situation.
Thank you so much, Satyen. I'm sure today's topic was very critical. Any HR partners who have not joined our call today, always refer to our recordings, which we will host on YouTube and as well as LinkedIn platform. Some of the answers that you've given, Satyen, it addresses most of the critical queries. Especially leave is a very personal agenda for everyone. Now, in this situation, people were getting ambiguous in terms of how do I utilize my leaves that has been utilized. Still, by staying at home, can I utilize it? And there were some examples that Lakshmi shared offline. I really appreciate those examples. Some of the FAQ list, the questions that you have posted over here, and some of the FAQs we have collected offline. We are going to print this in a public domain after we get a sanction from a legal personnel, and you will get this in a print form, which is like an e-form. Sorry, it will come in an e-print form for you, all of you guys, to refer to it, like a ready reckoner for all the HRs. You can refer to that. And on this note, Satyendra, thank you so much. You have been a phenomenal guide on this subject. Your knowledge on this subject is really vast, and I can always debate with you offline, and thank you so much for this. Lakshmi, thank you so much for coming on board with us and engaging us on an interesting dialogue. I'm sure there is a lot of takeaway for you as well from our session today here.
Absolutely.
Please do circulate to your fraternity, your HR partners, and your friends and peers. Thank you so much once again, and to the audience, have a good evening. Please stay tuned for tomorrow's webinar, which is on a DNO part 2, the continuity of the part 1 we had in the month of April. Thank you so much. Good evening. Stay safe. Stay well. Thank you.
Thank you.